Hello, everyone. The Kerala governor, Mr. Arif Mohammed Khan, has created a new controversy by saying that he has withdrawn the pleasure over a minister of the Kerala government. He has taken objection to certain statements made by the finance minister of Kerala government. And he has, in a letter addressed to the chief minister, he has said that he has withdrawn the pleasure over the minister. So this has given rise to a lot of discussions and debates. Can a governor withdraw the pleasure over an elected minister? And if he can, what will be the consequence of such an action by the governor? Will it lead to the dismissal of the minister, or the minister has to resign? Or has the governor overstepped his constitutional boundaries? So to discuss these aspects, we are joined by a constitutional law expert, Mr. PDT Achary, who was the former Secretary General of Lok Sabha. Welcome, sir. Thank you for joining with us. So, sir, what are your views regarding the decision taken by the governor? Can the governor withdraw the pleasure?
Well, the governor can withdraw the pleasure only on the advice of the chief minister. Because pleasure, after all, is not a personal or individual matter. Pleasure is constitutional pleasure. That means when the government in office has majority in the legislature, the governor has pleasure. And when the government loses its majority, the pleasure comes to an end. So that is how the pleasure operates. It is not that the governor can just withdraw his pleasure. When there is a government in office which has majority in the house, the governor's pleasure is supposed to continue. And at no stage, till the government loses its majority in the house, can the governor withdraw that pleasure. You know, under the constitution, the governor acts in exercise of his executive functions only on the aid and advice of the Council of Ministers. And the Supreme Court has made it very clear, this law is settled, that the governor cannot act independently other than on the advice of the Council of Ministers. And here, withdrawing the pleasure from a minister is also part of the executive function of the governor. That means he cannot do that except on the advice of the chief minister. And therefore, the point is, or the conclusion is, that the governor cannot withdraw the pleasure from a minister unless the chief minister asks him or advises him to withdraw that pleasure. Certainly, if the pleasure is withdrawn in the constitutional way, then the minister cannot remain in office, even for a minute. But if the governor says, I am withdrawing my pleasure from the minister without the advice of the chief minister, that is no withdrawal of the pleasure, constitutionally speaking. Means he can withdraw it only on the advice of the chief minister.
So in this context, several persons have pointed out one article in the Constitution, that is Article 164, which says that a minister shall hold the office during the pleasure of the governor. So this article has been pointed out by several persons to say that once the governor withdraws the pleasure, the minister can no longer occupy the office and he has to invariably resign. So what is your view?
Well, you know, that is true. The governor, once the governor withdraws the pleasure, the minister cannot remain in office. That is true constitutionally. But before the governor withdraws the pleasure, something else also has to happen, and that is the advice of the chief minister. Mm-hmm. Only then the pleasure becomes constitutionally valid. Only then we can say that the governor has withdrawn his pleasure. Otherwise, the governor is not supposed to withdraw his pleasure if the chief minister has not advised him to do so. That is the meaning of this particular article. Because governor has to withdraw the pleasure. If at all they continue or they hold office during the pleasure of the governor. So naturally, it is the governor who has to withdraw the pleasure. But then there are certain other requirements. Chief Minister has to advise him to withdraw the pleasure, and that is the only situation in which the governor can withdraw the pleasure. Means
So,
the governor cannot independently withdraw the pleasure. That is the point.
okay. So, which means that so if the governor has unilaterally withdrawn the pleasure without any aid and advice from the chief minister, so what is the consequence of such an action? That
it has no consequence at all. It has no consequence at all. The governor, more than anybody else, should have realized that.
So it is just
without the advice of the chief
individual
minister,
pressure of the governor. So governor can merely say that his personal.
No, if you interpret it differently, if you interpret it to mean that the governor has a pleasure is individual, and the governor can withdraw the pleasure anytime, that means no government will be stable. If the governor thinks that a particular minister is not good, so I'm withdrawing my pleasure from him, means chief minister will be a silent spectator or a helpless spectator. And how does the system work then? The system will collapse. That is not what is intended by the Constitution.
Mm-hmm. So you're saying that the pleasure as used in the article 164, that cannot be textually seen. That has to be interpreted as
Yes.
pleasure.
It should be read along with Article 163. Because these two articles, they should be read together. So there shall be a council of ministers to aid and advise the governor in the exercise of his functions. In the exercise of his functions, there has to be a council of ministers to aid and advise, which means a governor cannot exercise these things except on the advice of the council of ministers. And then comes 164. Yes, ministers shall hold office during the pleasure of the governor. But then, in order for the governor to act, there has to be a advice from the chief minister.
So both the articles, Article 163 and Article 164, they have to be read together. And so when read together, it means that it is only with the aid and advice of the Council of Ministers that the governor can exercise his executive functions.
Yeah.
The governor can act independently only when the Constitution confers him the powers to exercise his discretion.
Yes, that is only the discretionary area. That is.
So this is not an area where the governor can exercise discretion, that removal of a minister.
No, not at all. Not at all. Not at all.
So according to you, which are the areas where the governor can exercise his discretion?
See, there is a particular provision 371 in that article. The governor has been given a certain discretionary powers with regard to some of the northeastern states. Northeastern states. There, the governor has an additional power, which governor can exercise without the aid and advice of the Council of Ministers. And then, if the governor is the administrator of another state or another union territory or something, there also the governor doesn't have to act on the advice of the Council of Ministers of that particular state, of which he is the governor. Then the appointment of the chief minister, that is supposed to be an exercise by the governor under his discretion, because there is no advice available at that time to appoint a particular chief minister. That is entirely his discretion. Yeah. These are the areas, these are the discretions which are given to the governor, which he can exercise without the aid and advice of the Council of Ministers. But in respect of all other matters, for example, this withdrawal of pleasure, etc., that certainly is part of the executive function of the governor, which he can exercise only on the advice of the Council of Ministers. Council of Ministers speaking through the chief minister.
So in case, suppose someone approaches the High Court or a constitutional court saying that this minister has lost the pleasure of the governor and he should be asked to step down. So what could be the judicial reaction? Well,
of course, I can't can't say what will be the reaction of the judiciary, but they have to go into this, and they will certainly have to look at Article 163 and 164 together. And I don't think the judiciary will take a position against what I have said, or opposite what I have said.
Because that would be against the democratic spirit, because governor
Yes,
is...
that would be against that will be actually against the constitutional scheme, because under the constitutional scheme, the governor is only a constitutional head. Means, although constitution says that all the executive power of the state is vested in the governor, but then which he will exercise in accordance with the provisions of the constitution, which means in accordance with Article 163, 164, and things like, and articles like that. That is, so governor, although executive power, according to the constitution, executive power is vested in the governor, which he will exercise through officers subordinate to him. That means the ministers, in accordance with the constitutional provisions. That is it. So only in accordance with the constitutional provisions, a governor can exercise his executive functions. And what are the constitutional provisions? The main provision is that there shall be a council of ministers to aid and advise in the exercise of his functions. So that is the most important thing. And then, although it is said that ministers shall hold office during the pleasure of the governor, which some people may interpret literally and say that, look, the governor has the authority, governor alone has the power to discontinue his displeasure, and so on. But that is not how it is. If that were so, then things would have been differently worded. And then the result would be that there would be a total collapse of the constitutional system. Governor can at will dismiss any minister. Is it possible? It's not possible. No governor can do that. There is no power available to the governor in the constitution to do such a thing.
So why do you think the constitution framers use the word pleasure in that article? So they could have said, so long as the ministry enjoys the majority, the governor cannot dismiss them. Why that?
Yeah, that's a very interesting question. In fact, Dr. Ambedkar had replied to this question. This question was raised, I think, in the Constituent Assembly debates. Dr. Ambedkar said that because these words have been used in most of the constitutions in the Commonwealth countries, in the democratic countries, we also thought that it can be used because it actually it actually means that the governor cannot exercise this power except on the advice of the Council of Ministers. That is it. Although, technically speaking, governor is the authority who can discontinue his displeasure and the minister and say goodbye to the minister. But that exercise is done on the basis of the advice. That's how it is. So the words have been retained. In fact, you know, this pleasure doctrine originated in UK. In the olden days when there was monarchy, king used to appoint ministers and who were dispensed with at any time by the pleasure originated there. Later on, when the constitutional system stabilized, democracy came into existence and parliament became the center of power and all that. But they retained that pleasure doctrine. The monarch, yes, monarch will remain there. Monarch will express pleasure. It is the monarch's pleasure which will see that the government continues in office. That kind of thing. But in reality, monarchy will exercise that power only on the advice of the Council of Ministers. The basic principle is that a monarch or a president or a governor cannot exercise executive power except on the advice of the Council of Ministers. That is all settled.
So this use of the word pleasure, that is only a vestige of the monarchy. And it's just a colonial.
Yeah, they have read it. Dr. Ambedkar said Since it is being used in all the constitutions in the Commonwealth, so we are also using it. He said there is nothing beyond that. We should not attach any other meaning to this. That's it.
So in reality, in practice, it means that pleasure means the majority, the government enjoys the majority of the confidence of the House, and also the Chief Minister's aid and advice is also
Advice.
Is also there, right, sir?
Yeah.
So a governor who is unilaterally withdrawing the pleasure without any such aid and advice from the ministers, from the Council of Ministers,
that is no withdrawal.
that is only an individual action. It has no constitutional consequence.
Consequence.
Right, sir.
So constitutionally, there is no withdrawal. That is.
So
if there is no advice from the Chief Minister, constitutionally, there is no withdrawal of pleasure.
Have you come across any such situation in the past, any such precedent or which has come to court, or any other political precedent to your knowledge?
No, luckily, I did not come across any such instance.
Okay, so
this is perhaps the first time when such a thing has happened.
Okay, so thank you, sir. Thank you for explaining the context and explaining the ambit of doctrine of pleasure. Thank you.
I hope things are clear now. No.
Right, sir. Right, sir. Thank you so much. Thank you for spending.
Okay.